So good morning or good afternoon, everyone. Welcome to AELA's July webinar, where we're very pleased to have a special guest speaking with us today on climate conscious lawyering. But before I introduce Judge Preston properly,
Elizabeth.
Oh, hello?
Let's continue.
Oh, sorry. I'd like to acknowledge country. So my name is Michelle Maloney. I'm the convener of the Australian Earth Laws Alliance. I normally live in Brisbane and acknowledge the country of Yagara and Turrbal people, the land on which I live, work and play, and acknowledge the elders past, present and emerging. But this week, I'm really honoured to be up in the Kimberley meeting with the Martuwarra River Council of Elders, working with Anne Polina. So today I'd like to acknowledge that I'm here in beautiful Broome, and I'd like to acknowledge the Yawuru peoples of this country and all of the different Aboriginal nations across the Kimberley and across Western Australia. So now we will introduce Justice Preston. The Honourable Justice Brian Preston is the Chief Judge of the Land and Environment Court of New South Wales. And today he'll be speaking about climate conscious lawyering. Judge will speak for about 30 to 40 minutes and then we may have time for some questions. But if everyone could please stay on mute, that would be terrific. So over to you, Justice Preston. You're still on mute. Sorry. Justice Preston, you're still on mute. Can you unmute? Gotcha. Excellent. Thank you.
Right. Okay. All right. Well, thank you very much for joining me wherever you are around Australia. The topic is one about being climate conscious, and it's to do with in our lawyering work. So what do I mean by climate conscious lawyering? Well, let's start with what I mean by climate conscious approach. And the first is that it's an active awareness of the reality of climate change and then how that interacts with our day-to-day legal problems. So what does it involve? Well, at first, it involves actively identifying the intersections between the issues of the particular legal problem or dispute and climate change issues. And then secondly, giving advice to the clients or litigating or resolving the particular dispute in a way that meaningfully addresses the climate change issues. So let's just contrast that with a climate blind approach. So it's the opposite of that. So you identify that there is a legal problem or dispute that will impact upon climate change or be impacted upon by climate change, but nevertheless, the legal advice is given or the dispute is resolved or litigated without any attention being given to the climate change issues. So I'm going to put forward 5 reasons why we do need to be climate conscious in our lawyering. The first is that we, as lawyers, always need to give holistic legal advice, and I'll explain that. The second is that there is uncertainty and evolution in the law, and we are not able to give definitive advice just on the law because it's always going to be changing. The third is that this climate conscious approach accords with our obligations, our ethical obligations as a lawyer. And related to that, it accords with our duties as a lawyer to uphold and advance the values and the integrity of the legal system. And finally, it will also mean that we can integrate our own personal legal thinking with what we do. So our thoughts match our deeds. So let's go to the first one, this need for holistic legal advice. Now, when we think about legal problems or disputes, although as lawyers we like to think it's about the law, in reality, it's never really only about the law. So clients come to lawyers about a problem, but there are many different issues, some of which are legal and many others relate to non-legal matters. Now, to solve the legal problem, the lawyers may have to give advice on a whole range of non-legal issues. For example, the financial, the emotional, the psychological, the relationships and the social, the environmental and the ethical consequences of different courses of action. Now, why do we do that? Well, because then clients can understand all of the consequences. What are the costs? What are the uncertainties associated with alternative courses of action, and make an informed choice? Now, this idea that lawyers don't just give advice about law, but also about other things, and so as to give this holistic legal advice, is regularly acknowledged by various law associations. And a recent example would be in relation to human rights laws. So the Law Association for Asia and the Pacific, Law Asia, notes this in a publication about business, human rights and the environment. And they say that lawyers are at the center of issues of business, human rights and the environment, and they're expected to address these issues in their practices. The American Bar Association adopted a resolution in 2019 urging their lawyers to advise the clients of the risks and the opportunities that climate change provides, demonstrating this need for a climate conscious approach. Now, this idea that there is risks other than legal risks underpins this concept of a legal license and a social license. So now, for businesses that have social and environmental impacts, and we can think of it such as a mining corporation who's undertaking mining operations, they obviously have to have a legal license. But that will be insufficient. They will also need a social license. Why? Well, because without a social license, then the businesses may be exposed to significant business risks by society who see them to be illegitimate, taking action to protest against and to interfere with the business and its activities. And we can see, for example, the response to the destruction of the Junkun Caves in Western Australia. Now there was a legal license to mine, and that included to destroy the caves by explosives. But the reaction, justifiable reaction to that terrible destruction of cultural environmental heritage showed that there wasn't a social license to do that. And that has had major ramifications for the company involved. So come back, lawyers, if they were providing advice, should not only have advised about the legal license, yes, you have a license to go and blow up the caves, but also on the need for a social license. How is that going to be viewed? And so that would have been a necessary adjunct to the advice about the law. Now we can see that reputational risk was caused to the Rio Tinto in relation to the Junkun Gorge, but I've given you another one here by the mining company Shenhua up in Gunnedah in New South Wales, and again the threatened destruction of Aboriginal cultural heritage and artefacts in that area by the mining company prompted one of the super funds, CBUS, to divest from their shareholding in Shenhua. And we can see that in the newspaper article. So now let's see another example. Here, the Commonwealth Superannuation Corporation has decided to divest from companies that are pure coal miners. That is, all that they do is coal mining. So again, we can see this reputational risk to business. Now, what are the other ways? I've mentioned about social license, but can I just explain a little more about what are the other types of risks that face a business? And they traditionally are grouped into three categories. The first is physical risks. So climate change may induce extreme weather events. Those weather events may physically impact upon a business and its assets. So if you are, for example, located on coastal zones that are at risk of sea level rise or increased storm events, then your assets could be physically affected. Secondly, there's a transition risk. We know that there's a push for the world's economies to become carbon neutral. So by a date, and it's typically the middle of this century, being 2050 is the date picked. So net zero emissions by 2050. But to get there, there needs to be a transition. And that transition will mean there's a phasing out of major sources of greenhouse gas emissions and an increase in sinks to capture carbon emissions. So if you're in an industry that is going to be affected by this transition to lower carbon or carbon neutral economy, then there will be a risk to your business. And the third category is liability risks. We're increasingly seeing litigation around the world, and I'll refer to some of these cases shortly. But that means that the business stands to be held legally liable either for its contribution to climate change or its failure to adapt to climate change. So each of those three types of risks are risks that go beyond what lawyers traditionally might advise. You won't find in the laws any of those risks directly. So if you're providing a business advice simply about what the laws state, then you wouldn't be providing advice about these risks. But they are very real risks, and business needs to take them into account. So a holistic legal advice should provide advice about these risks. So just explain a little bit more of those. The physical risks I've explained, but we can see the bushfires that happened in the last few years in Australia, devastating effects. And then no sooner had that been finished, another of the horsemen of the apocalypse came, and it was floods. The transition risks, I've said about this transition, but we can see here the Secretary General of the United Nations urging countries to end the deadly addiction to coal. So that is flagging a transition risk. And, you know, that is being felt not only by businesses here, Rio Tinto, but also the investors in those businesses are, as the newspaper clipping says, turning up the heat on those emitters in order to speed up their transition. And the liability risks I've mentioned, but it's something that the directors need to assess. And I've given a quote from a former judge of the High Court of Australia, Ken Hayne, who says that a director acting in the best interest of the company must take account of, and the board must publicly report on, the climate-related risks and issues relevant to the company. And the other aspect, of course, is the not only managing the risk, but also disclosing it. And so there has been an increasing action by regulators, but also by investors, on the need for disclosure of climate-related risks. So I've given some reference to the work that ASIC is doing, but also APRA as well. That disclosure is relevant on the stock exchange for listed companies, and they again need to report on material exposure to environmental risk. And of course, that will include an exposure to climate-related risks. In New Zealand, there has been a change in the law so that from 2023, there will need to be a disclosure of climate risks for certain entities. Now, shareholders have been taking action because their shareholders, or the value of their shares, will be affected by these climate-related risks. And so we see action by it. Now, that may mean that there has been calls for resolutions at annual general meetings, or it could be that activist groups who own shares in it call meetings and AGMs in order to drive greater action. And there has been actual litigation. So for two fossil fuel companies, Exxon and Chevron, we can see there's a series of litigations. For Exxon, it has been by certain of the states in the United States. So Massachusetts and New York have both been taking action against Exxon in relation to their disclosure of their risks, climate-related risks. And in Chevron, there has been a recent action filed by various NGOs saying that Chevron has misled consumers about its commitment to reduce fossil fuel production. So it's a form of allegation that there's been greenwashing. We're also seeing actions against corporations. So the recent decision of Infancy against Shell, where the District Court of The Hague found that Shell violated its duty of care under Dutch law because it had an obligation to reduce its greenhouse gas emissions in accordance with the targets in the Paris Agreement. In Australia, there has been an action by one of the members of a super fund, the Retail Employees Super Fund, REST, because it was alleged that super fund had not adequately disclosed the climate-related business risks. Now, that case was ultimately settled because the super fund agreed to improve its disclosure. So, now we've just had a little time limit problem.
That shouldn't be coming from us, Judge. I would be getting it, not, that might be an old message. That's,
we'll settle it here. Here we go,
yeah.
Come back. It's a Zoom problem.
It looks like that's a message from a former meeting, perhaps, because with our Zoom account, it should be okay. We don't have time limits on our meetings.
A minute, and we'll come back out of it.
Yeah, thank you. Good luck. Technology is painful for all of us.
All right.
Well done.
That's a little excitement.
Sorry.
So that was my first big category. Now we come to my second category as to why it is that we need to have a climate conscious approach. So I've tried in my first category to say, look, we don't provide advice only about the law, we do provide advice about other things. But let's just focus for a moment on this idea that we are to provide advice on the law. What I want to say now is that what is the law is quite unclear. And so we're always going to take a sort of wider view. Now, how does that arise? Well, this is because there's always going to be doubt, and it flows from, firstly, the fact that there are choices in finding, interpreting, and applying the law. Secondly, that there's rapid evolution of the law, especially in an area like climate change. Thirdly, that court decisions retrospectively pronounce the law. And fourthly, that there's this interaction between law, policy, and fact. So let me just explain those four things. Now, when we say we're going to apply the law, the first thing we have to do is to find what is the law. The second thing we have to do is to interpret the law that we've found. And the third is we've got to apply that law to the particular facts. Now, each of those steps of finding, interpreting, applying the law is attended with doubt. And these doubts make it difficult to advise unequivocally on what is or is not the law. My second point was that there's rapid evolution of the law. And Liz Fisher has referred to environmental law, but particularly climate law, as a type of hot law. And that is that it's always evolving and often rapidly evolving. Now, this rapid change in the law makes it difficult to ascertain what is the law at any particular point in time. And so we can see in a recent decision of the federal court in the case of Sharma, the young people who brought the action against the Commonwealth Minister for the Environment, that it was held that there was a legal responsibility in relation to climate change under tort law. Now, before that decision, one might have thought there wasn't such a responsibility, but we can see it can change quite rapidly. And so I say that the idea that there are no or very few legal responsibilities, and that might have been the advice that lawyers had provided to fossil fuel companies or the carbon majors, well, that's being challenged by litigation, not only the case of Sharma that I've said, but other cases as well. So here's some others. Urgenda case, we know well, at each of the three stages of that litigation. So first, in the Hague District Court, there it was held that the Dutch government was in breach of its duty of care under Dutch Civil Code in negligence. The Court of Appeal upheld that decision, but this time in relation to human rights law. And the Supreme Court then upheld the Court of Appeal's decision also on human rights law. We can also see this rapid change in the liability of directors and of enterprises. I've earlier referred to the former Judge Ken Haynes' statement that company directors are under obligations to assess and manage climate risks. I've also referred to the decision the litigation by McVeigh against Rest, where it was agreed between the parties that there should be greater disclosure. I've also given a reference here to other legal responsibility enterprises in the Climate Principles for Enterprises. My third point here as to why there's this rapid change is that it's the way in which courts make their decision. So there is an action today, that is, somebody does something or fails to do something. That then triggers litigation. It takes a while before the matter comes before the court. Then the court makes a decision. But when they pronounce, even though that might be 6 years in the future, for example, they're coming back and saying what was the law and the breach of the law today. And so although it's not a retrospective pronouncement in terms, they're not retrospectively applying the law, nevertheless, it operates retrospectively. So that poses a problem. So the lawyers of today have to actually say, what might a court, 6 years in the future, decide what is the law today? And so they need to take that into account. My final point here is this interaction of law, policy, and fact. And that's particularly true in environmental matters, because it is this interplay between what is law, what is policy, and what is fact. And there is no bright line between those three. And so you can't simply say what is the law without also understanding the interaction of law with policy and fact. So let me come now to the third category of reasons why I say that we need to be climate conscious in our lawyering. And this relates to ethical duties of lawyers. Now, we know that as lawyers, there are the legal profession rules that we have to comply with. But they do not limit the ethical obligations of lawyers. Ethical obligations also come firstly from the legal profession's special status as a profession. And that status as a profession carries with it an obligation to abide by certain moral and ethical principles. And I've referred to a speech that the Chief Justice of New South Wales gave, and I'll just pick up some of his wording. So he says, ethical thinking does pervade all aspects of legal practice, from the relatively mundane task of providing advice about a contract for the sale of land to the conduct of a defence to a murder. He goes further to say that obedience to a comprehensive code of ethics is the defining characteristic of the profession of a lawyer. So what are these ethical duties? Well, we can think that incorporating climate change and its consequences into our daily legal practice could be seen to be an extension of this ethical thinking. And that should pervade all aspects of our practice. My fourth category is also concerned with ethics in one way, but is also concerned with values. And this is that the lawyers have an abiding duty to the court, but also to the administration of justice. And these duties involve supporting the integrity of the legal system. So this is not limited to simply upholding the law and obeying the law, but it's also about ensuring the efficient and the proper administration of justice. And as we know, these duties to the court and legal system override any particular duty to a client. Now, this involves the concept of responsible lawyering. And this is where we look at our lawyer's role as one which is owed to the court and as a guardian of the legal system. And so a responsible lawyer takes into account this duty to the court and to the administration of justice in advising clients and acting for clients. So if there are these grey areas in the identification, interpretation, and application of the law that I've spoken about earlier, then we need to opt for those decisions in identification, interpretation, application that will uphold the legal system, that will uphold the fundamental values and integrity of that system. And so when we come to climate change, there is climate change justice. And so it would involve advising and acting in ways that uphold and advance the fundamental values and integrity of the legal system and of climate justice. Now, if we can flip that over and we can say, well, you wouldn't take advantage of any loopholes or procedural rules or arguments, not only that lack legal prospects of success, but also that would frustrate the substance and system of the law and those values of the law. So, for example, one wouldn't advise clients to engage in SLAP suits against persons or groups who are seeking to advance climate justice. So the IBA issued a report, a model statute, which advocated closing loopholes that would work to frustrate access to justice for all. And my final area then is a personal ethical approach. And this is a more complex one because it is personal. The others, there has been a reference point, a touchstone in other external values or the law or the system. Here we don't have that for a personal ethical approach. So it is a more difficult one. But what I suggest is that we do need to try to integrate what we do and what we think. So I'm going to suggest 5 ways in which we can bring into our daily practice ethical approaches, and so bring this accordance between our moral convictions and our actions. So my first way is dealing with client counselling. And so when, as I've said, clients come to lawyers, they don't only seek advice about the law, they're asking about the resolution of a problem. And in that way, the lawyer can discuss all of the different aspects, not simply the law, but also talk about the rightness or wrongness of the client's projects. Now, I'm not saying we have to, as lawyers, thrust our views down the client's necks. But there's nothing wrong with bringing to the client's attention the potential wrongness of a particular course of action. It is then a matter for the client to decide whether they will change their ways. And my experience is they often do decide to change their ways. So this is part of this holistic advice that I have suggested is a proper approach. The second is in relation to promoting human rights. And so the impact of climate change on human rights is being increasingly recognised, and lawyers can uphold human rights by advising business as to how they can rearrange their affairs to be in accordance with human rights. The third is that there can be encouragement by lawyers of industry and the actors in industry to engage and advance efforts towards sustainable business models. And I've given an example of a set of barristers' chambers in London called the Chancery Lane Project, where they've written a book, which they call the Climate Contract Playbook. And it involves climate-friendly contractual clauses for corporate actors. And so there's a Paris Agreement compliant objects clause, or a clause for termination in order to secure a greener supplier. And so there would be a way in which the lawyers can assist industry actors to be climate conscious. The fourth is that we can sort of encourage reform of laws and policies. And so lawyers can encourage the three arms of government to try and better address the climate crisis. And they can also involve in intellectual activism. So legal scholars and practitioners can try to build climate consciousness and reform the law and legal systems to better address the climate crisis. And that can be done by publishing articles or books or indeed having webinars. And of course, there is a need to provide pro bono services to those engaged in trying to tackle the climate crisis. Another initiative that I saw was where students ranked the 100 top law firms in the USA in terms of their climate impact in three areas: lobbying, transactional work, and litigation, and then publicized that. And so brought to the surface and to attention what the law firms were doing, who they're acting for, and what sort of lobbying work they're doing. So I have suggested 5 ways in which lawyers can implement a climate conscious approach. I won't recap those, but in order to utilize these approaches, what is required is to promote and improve people's knowledge and understanding of climate change by lawyers. So I think that can be done when people first become interested in law by going to law school. So I think that at the law schools, there should be an integration of climate change issues in the all courses, not just the elective courses. That is, there should be a greening of the curriculum. And I think there should also be further opportunities for continuing professional development. So this should be regularly, the concept about climate conscious lawyering should be regularly included in the CPD programs by legal professional bodies. So with that, I'll conclude and happy to have any questions.
Thank you so much. We have a couple of questions in the chat, and if just while I start to go through them, if anyone else has questions, please just write them in the chat, and if time permits, we'll move through them in the order in which that I have received them, just to try to be fair, some sort of distributive justice. Justice Preston, our first question is from Phil, and he said, and I'm not sure if you've touched on it a little bit in your talk, but the question is, what's the latest legal position regarding businesses who are not properly disclosing all their climate risks to their shareholders and investors?
Well, I touched upon it a little bit there in those slides. It's a fuller advice would be required. But look, increasingly, there has been calls by sort of industry task force. So the Bloomberg sort of one, which called for climate-related risks to be disclosed. ASIC has picked up on that. APRA has picked up on it. In New Zealand, as I said, there's passed some laws which will require it. So we're increasingly seeing that happening, and businesses are responding. But insofar as there are laggards, then there's litigation, and that's what some of the litigation in America is involved with. We haven't had too much litigation in Australia, although there was the litigation against the Commonwealth Bank, which was brought, and the McVeigh litigation. So we are seeing some of these litigations which are action forcing. They're basically trying to drive companies to disclose in a proper way their risks. Thank you.
And one question about the Sharma case. Given it's a torts case, what impacts do you think it will have in terms of a precedent for other environmental issues and other litigants arguing that the Commonwealth has an obligation to its people?
Difficult to say. I'm not sure. I think Sharma wasn't quite expected. That's not to say it's not a good decision, but I think it's probably snuck in under the guard of people. So not sure that people have quite thought what will be the consequences. I know from correspondence with judiciary in the UK and Europe who were interested in the decision, because it came shortly after the Miller Defancy and Shell decision, as to whether this was signalling a change in the responsibilities of enterprises. But I think it's still early days to see what will be the significance for enterprises. But of course, the Sharma one was against the Commonwealth. But again, I think it's early days to see what will be the responsibility. So I think jury's still out at the moment on that.
Yeah, it's certainly being watched with great interest by many of us. Justice Preston, we have two questions. I'm not sure if you can answer them. They're actually about the CO2 and other impacts of wood heaters, particularly in Sydney. There's two questions, one from Arabella and one from Dorothy, which are connected. One is, what grounds do community groups have for legal action against state governments for inaction on the deadly product of people being allowed to use wood heaters? And another question is, does Justice Preston have any advice for communities to challenge peak organisations that represent wood heating industries and lobby governments with incorrect information about both climate change and community health?
Okay, well, I can't advise it as to what litigation you should take, but what I can say is that for any litigation, what you first do is look to see what is the relevant law or laws governing a particular activity. So if the activity is wood heaters, you say, well, what does it do? Well, there is a combustion of a fuel and an emission of a byproduct. So whatever is the chemicals and gases that are emitted. So you then go to say, well, what laws would govern that? Well, obviously, as far as emissions go, there may be various pollution laws. So you would go to look at the pollution laws to see to what extent do they cover. If it is an activity, you would see whether it's an activity that is regulated by local government planning laws, etc. You'd go and see those. If it's a source, that is where the input, you go to see where is the product coming from. And so you go look at an upstream approach and you see how is that regulated by laws. And so whatever is being burnt, you say, where does that come from? So I just get a little bit more light on the subject here, probably causing a bit more greenhouse gas emissions. And so that's what that's the sort of, I'm not giving advice about that, but that's the inquiry that you do. As you can see, I started with the downstream effects and how are they regulated, moved to the actual activity and see how that's regulated, then moved to the upstream effects to see how that's regulated. That's the sort of inquiry that one would make.
This is Arabella, Daniel. That was my question. May I just add to that or not?
I'd prefer if you could just perhaps wait. I have several other questions, if that's okay. If you are seeking specific legal advice on this matter, you could always contact the EDO. Justice Preston is very kindly talking to us today about some of the bigger picture issues. We've only got about 10 minutes left. So, but if you need legal advice, please do contact our wonderful EDOs. I'm sure they can assist in more detail.
They actually haven't responded to our requests. Thank you.
Okay, thank you for your time. I have two questions here that I might just read out together. One of them is a bit long, but Chris is asking, is there an idea of a threshold for company directors for disclosure, considering that Tcfd disclosures remain in infancy? For example, with REST yet to provide a Tcfd type report as part of the settlement. In other words, the obligation exists via ASIC. However, no guiding principles exist for, say, small businesses. I might just go with that one question to start with.
Well, look, what we're really doing is that at the moment, the inchoate obligation on companies and their directors to make disclosure about climate-related risks is not detailed, and we won't get it to be detailed until it really gets encapsulated in the law. At the moment, it's a general statement by these various organizations to say, thou shalt make proper disclosure about the business's climate-related risks. But it's leaving to the individual enterprise, what are those climate-related risks and how do you assess them and therefore disclose them? So it may well be there will be further rounds of litigation. The McVeigh type one is, as I said, at the inchoate obligation, that is, there should be such disclosure, but it's not until they make that disclosure that you can then test whether that disclosure was adequate. So I think, again, it's watch this space. There will be a working out of what is the detailed content of the disclosure requirement. But of course, it will be a matter of fact and degree. It'll depend upon the particular enterprise and its activities. I mean, the larger scale enterprises have greater capacity to make more detailed disclosure. Smaller scale enterprises, with less than, say, 20 employees, are going to find it quite difficult to assess and identify what their climate-related risks are. And hence, whatever disclosure they make might be quite spartan, simply because they just don't have the resources to be able to do the disclosure that is required. So I think there does have to be some recognition of it's horses for courses. And I don't think we're going to get a particular threshold or a particular detailed prescription of what each company needs to do.
Thank you. Another question here. Superannuation funds once gave fiduciary responsibility as a reason to not offer environmentally sustainable investment options. Is that argument now dead in the water? Oh, actually, I added in the water, sorry, me and my metaphors. Is that argument now dead? And it is now irresponsible to not offer sustainable low climate risk options?
Look, it's still, I don't think the argument's dead in water or otherwise. It's an interesting thing because corporations, and I'll start with corporations and come back to pension funds or super funds, but corporations exist primarily to create value for their shareholders. So that model of what a corporation does is a long-standing one, and probably is still championed by many corporations. And pension funds or super funds took that view as well. That is, they exist, the members invest their super, their pensions, and they hope to get as big a return on their investment as they can. So similarity we can see between corporations and superannuation funds. But that idea that the only driving force and sort of rationale for a corporation or a super fund is to maximize the return to members has been challenged. And it's been said that there are other views that should be done, that the role of a corporation is not simply to maximize the return to shareholders. It is also to be socially responsible. It could also be to create value by carrying out activities that are needed in society, that are valued by society, regardless of the yield that comes from carrying it out. So let's take a stark example. If one corporation was engaged in the manufacture and sale of weapons of mass destruction, you couldn't say that the only driving force for that corporation should be maximizing the return to shareholders. There may be a question of, should they be engaged in that activity at all? Should they divest from that activity and reinvest in some different activity? You see, so we can see that there are other criteria by which the success of a corporation could be evaluated. Now flip across to a superannuation fund. Can we take that logic and say that the driving force, the rationale for a superannuation fund should not merely be maximizing the return for members, but it should also consist in investing in socially responsible corporations or activities, because that is also creating value, albeit not economic value, for its members. So I think there is a broader debate happening in the corporate world, and that will be seen to be reflected in the shareholders and pension funds.
Thank you, Justice Preston. I have two questions about climate change and a linked one about activism, and then just one or two more general about community lawyering and climate conscious lawyering. So I think we'll be able to just squeeze those questions in, and that might be it for our time today. Gavin has asked a question which I will answer first and then hand to you, Justice Preston. He says, if the law is evolving and the science isn't settled, aren't we getting a bit ahead of ourselves? The evidence is growing that climate change is not a drastic problem as it was once thought. I guess as a lawyer myself and someone who works with a lot of scientists, I'd like to suggest that the evidence is absolutely committed to the fact that climate change is happening. The problems are accelerating. We've just recently, last week, had open public hearings from climate scientists such as Will Steffen and Brendan Mackey about the acceleration of the drying out of the landscape, which drove the 2019-2020 bushfires, as well as the heightening problems. And I'm here in the Martuwarra up in the room with elders saying there are certain water holes that they've never seen behaving this way before. And these are people who have collectively a memory of several thousand years. So I would like to suggest that when lawyers talk about science and uncertainty, it's not, is climate change happening or not? But it is some of the feedback loops as to this is happening fast and it's connected to this. Holy Hannah, we didn't know that was going to happen because we are shifting the system in such a way. But that's my answer because I'm passionate about these issues. And I believe it's a rational, reasonable answer to say dozens of thousands of scientists and Indigenous elders around the world are observing phenomenal climate change. But Justice Preston, I shouldn't take your space. Please respond.
The only thing I'd just add is this, is that in no area of human endeavour do we ever have 100% certainty. So, I mean, in the case of climate change science, we're well in the 90s of percent of certainty, but we'll have to accept there are certain predictions or certain statements of causal connections that may still have some small degree of uncertainty. But to which I say, so what? You know, when do we make a decision in life to only proceed to do something when we have 100% certainty? You know, if we just think about any single decision from the banal to the monumental in our lives, is there 100% certainty? When we decide to cross the road, there is a risk that we could trip, get run over, you know, something could go wrong. When we catch the train, when we sort of go to a restaurant, I mean, you know, with COVID and everything else, there's risk all the time. Yet, do we then sit here, as Cass Sunstein said in the title of one of his books, paralyzed by fear and never doing anything? Well, no, of course not. We have to make decisions on the basis of, you know, the best information that we have. And that's no different in climate change. As I agree with what Michelle said, we are very high certainty. Go and read the IPCC reports. They give you the degree of certainty of their various convictions and predictions. It's very high. But then based upon that, we then have to say, well, on that information, what is the best course of action? And that's what we're doing.
Thank you. And I think we might end on a really lovely question from Angela. She says, I'm a first-year law student at Macquarie University. What kinds of activism would you recommend young people take to effectively encourage the development of climate law and protection in this country?
Good one. Look, not necessarily this is my considered view, but just something which pops in. I thought that activity by the US law students ranking the law firms for their climate consciousness, my words, not theirs, was not a bad one. You could do the same to evaluate the Macquarie University and the law school to see to what extent it is, you know, climate conscious in what it's doing. What about doing a review of the law curriculum, that which you are being taught, to see whether, to what extent it integrates, you know, climate consciousness, to what extent, to use the expression, is it green? I mean, just pausing there and interrupting, if you think about it, doesn't matter what area of law, from administrative law, constitutional law, contract law, tort law, you could inject not only environmental cases, you know, to be decided by the courts, but also, you know, a sort of environmental conscious approach. And picking up on what Michelle has worked on and other things, a sort of a wild law approach. You know, one could see to what extent it could be integrated into it. Now, that doesn't mean that the law school would not be teaching the fundamentals of law. It simply means they're using other cases, other approaches to illustrate the fundamental principles of law. So there could be some ideas that you could do.
Wonderful. Thank you so much. And I know that we're out of time and you're an extremely busy person. So Justice Preston, thank you for your time. We hope to see you back in one of our AELA events again very soon. And thank you to everyone in our audience for your patience and for asking questions. And we hope that we've answered everyone's questions that we could get to. On that note, the only other thing I'll plug is if you're interested in the work that AELA does, please just visit the website. I normally do an introduction, you know, telling you all about what we do, but today I preferred to jump straight into our time with Justice Preston. So do have a look at earthlaws.org.au for upcoming events, creative projects, and how we shift the law to be not just climate conscious, but earth-centered and planetarily and locally conscious. So on that note, thank you so much, Justice Preston, and thank you to all of you.
Good.
Goodbye.
Thank you.
Thank you.